The opinions voiced in this material are for general information only and are not intended to provide specific advice or recommendations. To determine which investments may be appropriate for you, consult with your financial advisor. Turning 18 can be an exciting time, but for families raising a child with disabilities, it can feel like stepping into a legal minefield. In the eyes of the law, your child is seen as an adult beginning the day they turn 18. Now, they're suddenly expected to make decisions about their health care, finances, maybe even their future, regardless of whether they're ready or capable. So how can families raising children with disabilities prepare for what's to come? Joining me today is Kelsey Samasco of Samasco Law. So for parents listening who may have a child with disabilities who is turning 18 soon, what are some of the biggest legal challenges they need to be aware of, and how can they prepare?
So ultimately, every child, when they turn 18, is now the only person who's allowed to make their own medical, financial, and legal decisions. And so if you have a child who's not in a position where they're able to, right, they may have an intellectual disability, they may have been born with some disabilities that make it so they'll never really be able to. Parents now, for the first time, need the authority to be able to make those decisions. And you need legal authority from either the court or from the child themselves. Ultimately, what kind of authority you're going to get is going to depend on the mental capacity of your child. And, I think that's something we'll probably get into a little bit more later, but it really is something where you want to be meeting with an attorney before they turn 18 so that you know what you're going to need to do, so that on their 18th birthday, you can just, kind of file what needs to be filed or sign what needs to be signed. Okay. Another thing to consider is disability benefits. And so once you turn 18, these individuals may be able to qualify for some kind of SSI benefits, Medicaid benefits on their own. And so it is important for parents to know what benefits will be available to their child so that they're able to file those applications in a timely manner.
How do you think parents, should start preparing? What are the first steps they need to take?
Yeah, here's the thing. Everyone is in the same position where they know they're going to have to do something. They're just not sure what they're going to have to do. And so what you should do is you should start, asking your resources about attorneys that you can contact to discuss these things, right? It could be your child's pediatrician. It could be teachers at your child's school. It could be, friends or family members who maybe are facing something similar or, they have faced it in the past. And so first you really want to go to that village you have around you and ask for recommendations. Right? Most people, especially when it comes to hiring like a doctor, an attorney, anyone, you don't want to just go by Google reviews, right? You want to meet with someone who other people have had a great experience with. And so find someone who you think will do a great job, but really make sure that you're going to speak to an attorney that knows what they're doing in this sphere. Lean towards going and seeing an elder law, disability law specialist, right? Even though your child isn't elderly, usually the people having to get these authorities are the elderly. And so we're really good options to be able to navigate everything. And it's nice because we can navigate things for your child, and then we can help navigate things for the parents as they're getting older too.
Okay. Well, that is nice. Yeah. So it's not all on you, really. It's not all on the parent.
Yeah, and really, it's a stressful situation because you're taking care of your child. You're having to, switch some things up, I'm sure, within your own household with them turning 18. Let us take this off your plate for you, right? If there's one less thing you have to worry about, let there be one less thing to worry about. You already have so much going on that really it's nice for us as practitioners just to be able to lighten the load a little bit.
Yeah, for sure. So maybe For people who don't know, what kinds of decisions are legally handed over to the 18-year-old on their birthday?
So it's all decisions, right? And think of it like less in the sphere of, you have a child with a disability, and more in the sphere of you were once 18, right? And the day you turn 18 is the day you are, the age of legal majority. Once you're the age of legal majority, you're the only one who can make your doctor's appointment. You're the only one who can make your medical decisions. You're the only one who can open up bank accounts in your name, right? You can be sued. You can sue people. You can do pretty much anything aside from drinking alcohol and renting a car, right? You can get called for jury duty.
Right.
And so, like many of us have faced, right? You turn 18 and your parent is going to call the doctor to make you the appointment to, get your shots before you go away to college. Your doctor is going to say to your parent, we can't talk to you. We can't talk to you. Who are you, right? How do we know you have the ability to make these decisions? Because parents aren't just default able to make their 18-year-old decisions, right? Spouses default aren't able to make their own decisions for a spouse. And so you need to get the authority to make those decisions. So when you call the doctor's office to make your child the appointment, and the doctor's office says, well, who are you? How do we know you're allowed to do this? You're allowed to send over the paperwork that says, here's the proof I'm allowed to do this.
Yeah. So how do they go about legally obtaining authority? I'm sure that's power of attorney stuff. What kind of documents do they need? And can you kind of just go over how the power of attorney works? Maybe what the difference is between that and legal guardianship?
Yeah, absolutely. So powers of attorney and legal and guardianship and conservatorship, in effect, do the same thing. Both documents say, I, a third party, whether I'm a parent, a sibling, a spouse, whoever, I have the authority to make this individual's decisions on their behalf. Ultimately, guardianship is similar to a patient advocate. It's over medical decisions. Conservatorship is similar to the durable power of attorney. That's over financial decisions.
Okay.
Ultimately, whether you're going to be doing guardianship, conservatorship, or powers of attorney, patient advocate, is all going to be determined by the level of capacity that your child has. In order to sign up power of attorney documents, an individual needs to have, it's called testamentary capacity, where it's you know who you are, you know who your family members are, you have an idea of, kind of what assets you have, right? Do you have a bank account? Do you own any property? Do you own a vehicle? And you have to be able to determine who you would want to make your decisions if you weren't able to, right? And so if you have a child who maybe is on the spectrum but is very high functioning, they probably will have the capacity to do powers of attorney.
Okay.
Powers of attorney are different than guardianship, conservatorship, because powers of attorney are the individual named in the document giving someone the authority to make decisions on their behalf, right? I, 18-year-old, am giving my mom the authority to make my medical decisions. I'm giving them the authority to make my financial decisions, right? Whereas guardianship, conservatorship is if an individual does not have the mental capacity to make those decisions, right?
Okay.
If you are someone who was born with severe cerebral palsy, right? Or you are someone who is operating at a function of, a child, right? You probably don't have the capacity to sign up the powers of attorney saying, this is who I want to make my decisions. If you're not able to sign up those documents, then parents have to petition the court to get guardianship and conservatorship. If the individual can't give you the authority, probate court is the entity that has to give you the authority.
Okay.
The tricky thing with probate court is when the judge gives you the authority, the judge also wants to keep an eye on everything you're doing to make sure you're not, doing a bad job.
Or taking advantage,
right?
probably.
Yeah, exactly. Taking advantage. They're going to be your babysitter. And so if you're in a position where you need to be making big financial moves, to get an individual qualified for Medicaid or, buy or sell property, you need to petition the court before you're able to make those big moves. And so initially, to get guardianship and conservatorship, it takes about 4 to 6 weeks to get in front of the judge to get the paperwork giving you the authority.
Yeah.
Every other thing you have to petition the court to do is going to take those 4 to 6 weeks. And so if you're ever in a situation where time is of the essence, we have to wait so long to get permission that usually we kind of miss the window of opportunity.
Yeah.
Whereas, powers of attorney, we're able to just make those moves without asking the court for permission. And so as a practitioner, my best case scenario is let's try to get power of attorney first, because that gives us a little more latitude. It gives us a little more flexibility to do what we need to do whenever we need to do it. But if you're in a position where that's just not an option, you're not sunk yet, then we just go for guardianship and conservatorship.
Okay. That makes sense. I want to pivot a little bit to government benefits just because that's been making headlines so much recently and has caused a lot of anxiety and angst for people.
Yeah.
With that big, beautiful bill passing, how does that impact families that are kind of taking care of adult children that are disabled? With that legislation now becoming law, what do parents who have children that are about to be 18 that are disabled or already have, they're over 18, but they're still dependent on their parents for care?
Those families need to know that there are now additional hurdles that you need to overcome, right? The biggest one that so many people are concerned about is the work requirement, right? And the work requirement applies to Medicaid recipients. And so for these individuals, it's going to be that arm of Medicaid that provides health insurance benefits. And so ultimately, now the rule changes are saying that in order to be eligible for benefits, you have to have 80 hours of work time, community volunteer time, education time, or you have to be enrolled in school at least part-time, or, a combination of the mix of the three.
Yeah.
Right? It has to equal a total of 80 hours a month. And when you apply for these benefits, you have to have done those 80 hours the previous month. And so they're going to look back at last month and say, all right, did you do your 80 hours? If yes, great, you meet the work requirement, you're fine. No, do your 80 hours and apply next month, right? And continue to do these 80 hours of work or volunteer schooling each month. Some individuals are exempt from that, though, right? There is a disability exemption that says if you are disabled, if you are not able to work for whatever reason, you don't have to complete that work requirement. Some disabled children who are extremely disabled, right? You're in a position where you're never going to be able to work because you're too medically frail, right? You have, you just don't have the mental capacity to, right? There are exceptions for those individuals, but you have to prove that you fall under an exception. And so that could look like a doctor's note. You have to know to get those doctor's notes while your child still has insurance, right? Because we're going to see a position where a lot of families are in the position where they don't really know they had to apply for these benefits. They go to apply for it a month or two after the benefit is lost. And now they're going to have to go out and pay out of pocket for doctor's appointments because they're no longer covered by this insurance.
Right.
And so you have to be extremely, extremely proactive in getting all of this documentation together, right? So there's not a cost hurdle that you have to overcome.
Okay.
Another thing that they're doing is they're changing the redetermination period from once a year to every 6 months. And so now that means every 6 months, families are going to have to be submitting verifications showing that their loved one is still eligible for Medicaid, right?
Yeah.
If you have a child who does not fall under one of the work requirement exceptions, That's going to mean showing documented proof twice a year that your loved one is meeting those work requirements. And so, as parents, right, you're still going to be your child's caretaker at that point, even after they turn 18. You also need to kind of become HR of their, employment, their volunteer service, their education, to make sure when you have to submit those verifications, you have it right on hand.
Right, which is a lot for someone that's just a lot for someone to manage for somebody else, especially if they're working themselves.
Yeah. And we also are seeing changes with that work exemption where parents taking care of children and, sometimes disabled children don't have to meet the work requirement, right?
Yeah.
But child stops when you turn 18. And so parents could be in a position where they themselves are receiving Medicaid benefits and they're going to have to start meeting this work requirement or showing that they fall into one of those medical exemptions. And so again, for children, for parents, you need to be getting these records now while you still have insurance to go to the doctor and get those notes stating you have a qualifying disability. We also are seeing, especially with Medicaid, we're seeing cuts to kind of peripheral Medicaid programs that are designed to keep individuals living at home, right? And so sometimes there are some programs that will cover in-home care. It will cover taking your loved one to like a day facility every day. It will cover, helping you take them to and from doctor's appointments. A lot of those programs are getting their budgets cut with these Medicaid benefit cuts. They're the ones we're really seeing the most cuts to. And so if you're someone who thought that would be an option to keeping your child at home and, maybe making it so you can continue to work as much as you were working in the past with your child being in school, that's something you're really going to need to consider. And you're going to start having to look at alternative options. The tricky thing, though, with alternative options and at-home care is they're most likely going to be private pay. And right now, the private pay rates for at-home care is about $30 an hour. And so if you're someone needing 24/7 round-the-clock care,
yeah, that's astronomical.
It's going to shake out to be about $700 a day. And that's right now before the demand for those services has started to increase. And so I imagine that those prices are also going to increase.
Right, which who can afford that? Honestly,
I know, already it's not an option for most people. And now, all right, the 5% it was an option for, I don't know if it's going to be anymore.
Yeah. And to kind of add to it all, I guess, because we're kind of talking a little bit about, like, we're getting into the estate planning realm. Maybe how do parents navigate estate planning for themselves and making sure that their child is going to be protected if their child is, like, solely dependent on them? So I guess I'm thinking more in terms of a child with disabilities who's not, like, high functioning, like maybe is nonverbal or something like that. How do you even approach estate planning as the parent or caretaker of that person?
The best way to approach it is by seeing an elder law attorney, even though you're not in a position where you're elderly yet, right? Elder law attorneys are largely the attorneys who do the most high-level estate planning that you're going to need. Start with your own stuff. Right. And so if you have a child who's 17 years old and you yourself don't have your estate plan yet, go get your own estate plan done. Right. Try out a couple lawyers for yourself, meet some, feel them out, decide if you like them, and then just be very upfront and say, listen, we have a couple kids. One of our, children has these disability issues and we don't know what to do. Yeah. Right. And at that point, the lawyer's going to be able to say, you know what, while I'm prepping all of your documents that you're going to need, let me prep all the documents for your child too. So then that way, if your child is within, 2 months of turning 18, I, as the practitioner, will say, all right, come in a couple days after their 18th birthday and we'll see if we can sign everything up at once, right? If your child is still, 17, they just turned 17, or they're 16 and you're just trying to get a jump on everything, we'll start with parent stuff. We'll start with their estate plan. We'll start with their powers of attorney, a trust if they need a trust. to protect their child's inheritance from the government taking it for disability benefits, we can sign up your stuff and then get everything locked, loaded, ready to go. So when the child turns 18, we can just file what needs to be filed and sign what needs to be signed.
Okay.
But I always really like to take it from that approach, because then to the child, it feels a lot less scary, right? It's not just, hey, we have to go to the lawyer for your stuff. It's mom and dad already have to go see this lawyer. We're going to go check it out, and we'll let you know if it's something you need to come in and help us with.
Yeah.
And that way, too, if it's a situation where child is going to be signing documents, they're able to see that their parents are also signing up documents pretty similar. And so it's something that all of us need to do at some time in our life. It's not just something that they need to do because, they may be perceived as different.
Yeah. I think that's so...
Every 18-year-old...
Oh, sorry.
Go ahead.
I was just going to say, I think that's so interesting that parents kind of, in this case, need to look at themselves first. Like, would you say they probably... Do they need their own estate plan before they can plan for their child's?
You don't need it, but I find that a lot of families like to use their own estate plan to kind of test the waters.
Okay.
Right? And it's because every family who loves their child wants them to go and, work with practitioners who are compassionate and friendly and competent. And it's a really easy way for you to be able to test it out, right? And I think that this is kind of a funny example to use. But like when I was a child, right, I always went to the same dentist that my mom went to. And because my mom would always say, listen, I want to make sure you're going to someone who's good. I want to make sure you're not going to someone who's hurting you and is going to be a jerk. And so my mom would always go and try him out first and say, listen, this is a good one, right? Your mom got your teeth cleaned by him. You're going to be great.
Right.
When parents are able to approach their child with having had the personal experience of I've met with them and I think they're going to do a good job, it just makes it a lot less scary. Right. And a lot of people in this position, you don't want to be subjecting your child to the unknown over and over and over again. And so you're able to go in and just, say, listen, I need stuff for myself. I need stuff for my child. If you meet with the attorney and you decide, you know what, I like them, I want to get it all done at once, let's do it all at once. Right. But if you're someone who wants to start slow, you can always start with your own stuff. And then it's sometimes easier to understand it within the context of your own life. And then it's easier for you to kind of put yourself in the position of your child and say, all right, as someone who, was in that position before, what would I have also liked to know before going in?
Yeah. Yeah. You brought up receiving an inheritance and how that can impact benefits for a disabled child. What should families do to kind of navigate that issue when it comes to leaving an inheritance but not wanting to mess with or void the government benefits? What options do they have?
So most government benefits, especially for individuals who are disabled and were never able to work the qualifying 40 quarters, so 10 years, right, to get traditional Social Security benefits, these Social Security disability and these Medicaid benefits are asset-tested benefits. And so that means before you get the benefit granted, the government is going to look and see what you have in your bank account. And if you have too much money, you're not going to receive the benefit. Or if you're someone who's been receiving a disability check every month and you're on Medicaid health insurance benefits, if you get an inheritance, you have to disclose that inheritance to the Department of Health and Human Services. And if your inheritance pushes you over the limit, depending on whether you're single or married, you'll be kicked off of your government benefits. And so the thing I see happen a lot is parents think they're doing the right thing by saying, look, I've got this disabled child. I'm going to leave all of my assets to this child so that they can use it to take care of themselves, right? And they leave it to them as an individual. Now that individual has too much money sitting in their bank account and they're kicked off of their Medicaid benefits. And they're kicked off of their disability benefits that they've been surviving off of every month. And unfortunately, a lot of families are in the position where they're going to be passing enough money over to a child to kick them off of their benefits, but not enough money where the child will go, well, hot dog, I didn't need that anyways, now that I've got these millions of dollars from my parents,
Right.
right? When you have a disabled individual, there are like 3 different kinds of bank accounts they can have. There's a traditional bank account where it's a checking, right? My checking account, I have full control, access over it. I'm the only one who can, mess around with it unless there's like a joint owner on it, right? Or I have a power of attorney who has access.
Yeah.
That bank account, a lot of times for government benefits, has to be below a certain amount of money. In the past, it was $2,000. Now with the Medicaid increases, it's $9,660, right? Any money in that bank account is countable for government benefit purposes, and the individual has immediate access over it, right? And so you never want that account to get too high. In Michigan, though, for disabled individuals, there's something called a MyAble account. This is a special kind of bank account that is exempt from a lot of government asset programs, right? Where they're not allowed to use this bank account against you when applying for benefits. With this MyAble account, though, there are limits to how much can be contributed every year. And so mom and dad are able to fund this account, but it can only be used for qualifying disability expenses. And so, care expenses qualify, but sometimes not all rent payments qualify, right? Therapy qualifies, but buying groceries might not qualify. This account parents have to be careful about, because a lot of times you don't want the disabled individual to just have free access to this account, because if they're spending money on things it shouldn't be spent on, you're going to get a tax penalty and you're probably going to get in trouble with your benefits, right? And so a lot of times what parents will do is they'll keep some money in the child's just regular schmegular bank account that they have access to. They keep some of the big money for disability expenses in this MyAble account that the child does not have direct access to. And then they put all other funds, birthday gifts, inheritance, graduation gifts. They put that in that third-party special needs trust, because that trust account is not countable for Medicaid and government benefit purposes, and there's no rules on how that money has to be spent. And so you can't spend your MyAble account on vacation, but you can spend money out of your third-party special needs trust on a vacation, right? You might not want to spend money out of your bank account on a vacation, because that's where you're buying groceries and that's where you're, paying your Netflix subscription from. But you want to be able to use the money in your special needs trust to go on vacation, because that's, the inheritance that grandma left you.
Right.
And so there are 3 kinds of bank accounts or types of bank accounts to be aware of. I usually find that families who are using a combination of all 3 of them are going to be the most successful, because you're able to kind of have your cake and eat it too, by saying, all right, I'm going to keep some money over here that can be used for, qualifying expenses, and you get a tax break on the growth in those accounts too. And so it's pretty nice. I'm going to keep some money in their checking account where this is, kind of their fun money. They can spend it on whatever they need to spend it on. And if they spend it all on anything, they won't get in trouble. And then we have, kind of the big daddy money in the special needs trust. And that's going to be, again, inheritance, large graduation gifts, things like that, where we're able to protect it from government benefits.
Kind of piggybacking off of that, and I think this is my last question for you. What are some other red flags that you've seen where families might think they're doing right by their child, or, getting all their ducks in a row, but what is something that they could be doing that could actually be putting their child's benefits or rights at risk?
So I usually say that the worst thing parents do is they just immediately go and file for guardianship, right? Because you file for guardianship, you file for conservatorship, thinking, all right, this is the exact right thing I need to do, when really maybe a power of attorney would be more appropriate, right? And you tie your hands by doing things that quickly without consulting an attorney, right?
Yeah.
Another thing we see, is people just leaving inheritance directly to a disabled child instead of going and speaking with an attorney about the ramifications of leaving that inheritance to that child just as an individual, right?
Right.
One thing that parents also really, really need to be considering, and it's the worst thing in the world to have to consider, but it is what it is. You have to, is God forbid if something happened to mom and dad or something happened to the caretakers, who should be on deck to take over, right? Because in Michigan, you're able to name a guardian and a conservator, and you're also able to name backup so that if it all hits the fan, you're not, in a rough position.
Yeah.
And so it's really important to sit down and have those hard conversations to determine who should be in charge, right? That way, too, as mom and dad get older, that individual who's going to need to take over will be able to start stepping up little by little and start, learning, well, what is their day-to-day routine, right? What expenses do they have? What issues do I need to be aware of? So that then you're not getting, baptism by fire
Right.
if something happens to mom and dad and all of a sudden you're forced to take over.
Yeah, that's always been my biggest question is what happens in those situations if something unexpected happens to the primary caretaker, so like the parent, for example.
Usually what'll happen is, if mom is the primary caretaker and something happens to her, dad will take over, right? But if dad has passed away or dad's not in the picture, then fingers crossed, that individual has a sibling who'd be willing to, kind of take up the job.
Yeah.
Unfortunately, the trickiest situations are if there are no other siblings or no other individuals who really would be able to take over, then you really need to take the time to find someone, right? Or you need to start, creating the relationship so that someone would be willing to take over if something happened to you. Because even if you're going to be in a position where a third party, agency will be taking over, there still is going to be those couple of weeks where someone needs help with the day-to-day.
Yeah.
And it's nice to have someone named so that if they hear something funky's going on, they know, all right, I'm the one who should be going over there and finding out what's going on.
All right, that does it for this edition of Not Your Father's 2 Cents. Sources used in this episode will be linked in the description. If you like this show, please let us know. Give us a comment, like, subscribe, share with your friends and family. Help us get the word out there so we can keep making episodes. Thank you so much for listening, and I'll meet you back here next week.